So far as the notes of Assistant Legal Advisor and Director General are concerned, it was submitted that no reliance could have been placed on the same by the High Court, as they were internal communications and they having not been publicized, the same could not have been treated as official communication made by the competent authority. It was further submitted that the same were only official notes in the course of processing of the files of the respondent, and that the same could not have been treated by the High Court as orders issued and publicized by the competent authority, and therefore the disposal of the writ petition on the said note was invalid and unjustified. It was also submitted that neither the CAT nor the High Court has any power to direct absorption of the respondents when they had worked only for 2 years, and on the date when the original application was filed before the CAT, they were not even working as casual workers. The further submission of the counsel appearing for the appellant was that the office memorandum, which was issued in 1985, could not have been relied upon or made the basis for issuing orders in favor of the respondents, particularly in view of the fact that on the date when the aforesaid office memorandum was issued, the respondents had already been disengaged from service and were not working with the appellant number 2. The aforesaid submissions of the counsel appearing for the appellant were refuted by the counsel appearing for the respondent, contending inter alia that since the note written by the Director General, to which reference has been made by the High Court, as also the aforesaid communications between the authorities were in favor of the respondents, both the tribunal and the High Court were justified in relying on the same for issuing necessary directions to the appellant. It was also submitted by him, as has been held by the High Court, that there was a clear discrimination for 10 persons who were similarly situated as the respondents were absorbed by the appellants, whereas the respondents were denied similar benefits without any reasonable explanation for such hostile discrimination. In light of the aforesaid submissions of the counsel appearing for the parties, we have considered the entire records. So far as the office memorandum dated 7/5/1985 is concerned, the same was issued by way of relaxation of the condition of recruitment of casual workers. But the fact remains that the respondents worked with the appellants only for 2 years, that is from 1981 to 1983, and admittedly on the date when the aforesaid office memorandum was issued, they were not working with the appellant number 2. There is nothing in the contents or in the language of the said office memorandum which would indicate that there was an intention to give a retrospective effect to the contents of the said notification. Instead, the language used in the aforesaid notification clearly shows that the same was intended to be prospective in nature and not retrospective. An analysis of the above reproduced provisions shows that in terms of Section 3, the state government can requisition any premises needed or likely to be needed for any public purpose. Section 6 provides for disposal of premises after the same are requisitioned under Section 3(1). Under that section, the state government has been bestowed with the power to use or deal with the requisitioned premises for the specified public purpose. Section 11(1) postulates payment of compensation for the requisitioned premises. The amount of compensation is required to be determined by either of the two modes prescribed therein. If the parties voluntarily enter into an agreement on the quantum of compensation, the amount is to be paid in accordance with such agreement. If there is a tenant in the requisitioned premises, then in terms of Section 13, the collector is required to decide whether the agreement for payment of compensation shall be entered into with the tenant or with the immediate landlord of such tenant. In case the parties cannot agree on the quantum of compensation, the state government is required to appoint a district judge or an additional district judge as an arbitrator and notify the same in the official gazette. Rule 8 provides that where the amount of compensation payable under Section 11 cannot be fixed by agreement, any person interested can make an application to the collector for referring the case to arbitration. Thereupon, the collector is obliged to refer the case to the arbitrator and give an intimation to the person or persons interested and the state government. Where no such application is made within a reasonable time, the collector can suo motu refer the case to the arbitrator and give the required intimation. Source 3P Legal RHC exercise number 16. Words are 798 and speed is 80. Speed is 100.